that they should have permanent status in this case.
They get permanent status, bitch. We're publishing you right now. You in the news now,
They're
bitch.
already here, as we well know. But we do think how
don't realize we live stream in the courtroom, the clown house.
The court should exercise.
It's already in the public, bitch.
It's very clear what everyone's roles are here.
Hello?
And
what are the roles, bitch?
Put in their briefing.
We want to know who the fuck
observers.
killed Charlie Kirk.
Neutral observers.
Who the fuck killed him?
We
Hello?
don't want the chaos that is out in the media in this courtroom.
Well, of course you don't, bitch, but welcome. Chaos is at your gates, bitch. Hello?
Does the court have any questions for me?
No, we ain't got no questions, but why are you gonna cry, girl? Don't cry. Take a deep breath. It's gonna be okay.
Counsel.
We're already live streaming you to Clown House. We got you.
Thank you, Your Honor. Just very briefly,
lawyer,
I'm not sure what neutral observer is supposed to mean. We have interests in the case. We're here to advocate for openness.
Don't go to law school, they told me.
I
fucking hate lawyers, that's what they said. Don't go to law school.
To imply, but
fucking hate lawyers, they said. I said, you hate lawyers, maybe I should be a lawyer. It should have been a lawyer. But now we're doing legal news.
Just a couple clarifications. Counsel said we haven't cited any criminal cases where this has been allowed. That's not true. We cited the court to 8 different cases, all criminal cases in the state of Utah, where this is the procedure that judges routinely follow, including
this is a special accommodation because Charlie Kirk got assassinated. He didn't die in a fucking grocery store. Stick up, motherfucker!
202.04. I don't think she meant this, but as the court probably knows, that just deals with court records. We're also entitled under governing constitutional case law to advocate against the closure of proceedings. And that rule does not technically apply to proceedings. It just applies to records. So just to be clear, but I think we have been clear, and this was all, I mean, there wasn't a whole lot of daylight between what counsel was just suggesting our role should be and what we've asked for, you know, which is just if they file a motion that seeks to prevent, that wants to classify something as non-public, like they did last night with the motion to disqualify. They were able to at least provide that to us. It's not very hard to send an email. That's all that we've asked for in terms of the notice. And then we have the right to be heard on those issues. And so I didn't really hear from counsel any reason why we should not be granted limited party status in this case, other than just some sort of, you know, confusion on their part as to what that would actually look like. I don't know how the clerk deals with parties on the docket. I assume you guys can sort that out. Typically, when we intervene on behalf of the news media in cases, they are listed because they are limited purpose parties. But the court can, you know, if it doesn't want to hear from us on a particular issue, it can certainly say that. I mean, we don't have any interest in weighing in on aspects of the case that don't have anything to do with the public's right to know. And so I didn't really hear an argument against what it is that we are asking to do. Just one last point on, well, 2 things. One is that counsel's chastising us for filing something late. I mean, this was a stipulated motion that got us here today. We weren't asked to weigh in on it. It was submitted to Your Honor an order, you know, which they just assumed you would sign because it was stipulated. It was only because this court said, no, I'm not going to do that. I want to actually hear from the parties that we weighed in. So this was not your typical, like, deadline where we were invited to weigh in and just didn't. Last thing is, in terms of docket access, you know, Mr. Hunt and Mr. Judd and I are all officers of the court. If the court says you can have access to things that the parties are seeking to classify as non-public, but you can't share them with your clients until further notice from the court, that's fine. Some judges do handle it that way. Sometimes we just, you know, if they don't concern closure, sometimes we don't weigh in at all. But, you know, when
what a pretentious fucking lawyer
under seal, and we're not allowed to
America, this is the problem.
You know,
you hear this?
Typically, the way
this is all about how to censor.
We are allowed attorneys' eyes only
how to silo,
you know, documents,
how to prevent the truth from coming out to the public
counsel can see
and getting this jury the information they need.
Unless the court
find the truth.
If the court decides no, this really doesn't need to be filed under seal, then we can provide it to our clients at that time. But this idea that our clients are somehow going to get access to things that are public. That's just not the way this typically works. If they're not public on the docket, if they're public on the docket, anyone can get them. And if they're not public on the docket, then our clients can't get them. And if there's a procedure where we can see them so that we can give the court the benefit of briefing substantively as to what it is, then we keep them attorney's eyes only until the court orders otherwise. And that's just typically the way this works. So, thank you.
Anything further?
Your Honor, I'm not going to belabor what's already in briefing. I do think it's concerning to just cite to a bunch of trial court cases without providing any pleadings or context for what occurred in those cases. I can't argue against what happened in other cases. This is our case. Our case is different. This court has already acknowledged it. There are many interests. We have concerns about leaks, information getting out that shouldn't be out. I think those are valid. And our concern is access. I'm not impugning the integrity of these gentlemen. I'm sure they would act as officers of the court. But the more this court controls the information that ultimately it determines to be private, the more able we are to identify if there are leaks, if there's information that's getting out that shouldn't be, and who did it.
All of the
So we are
starting their
objecting to
spaces.
providing
Please
the
repost
media
the space by
our
the corner. Thank
pleadings
you.
in advance, even just to their counsel. We don't think it's appropriate to see any authority for that. We're asking the court not to consider that. And we're concerned about opening the door to multiple other entities just filing in on this case, getting involved in the proceedings. We don't know exactly what media means either. So our position is and remains, they can file what this court has authorized to file in the manner this court authorizes to file it and be heard in the manner this court indicates. We understand they're entitled to closure hearings, and I did make a mistake. We agree that they have standing to object to closure as well. So they should be able to file those things, but we do not agree that that requires status in our case. So, does the court have any questions?
No, thank you.
Thank you.
All right. Appreciate the argument from all parties throughout this day. I wish to commend the preparation and the quality of the arguments, as well as the civility that is sometimes overlooked, but I wish to recognize that and appreciate counsel's demeanor and their arguments today. I previously stated when we began that I would be issuing rulings on the first issue, and when I began, I initially said October 14th. It's actually the October 24th audio recording of the closed hearing, as well as the October 24th transcript of that hearing. And so I wanted to create, just make that small correction. Given the in-depth and necessary arguments made in the closed hearing, I wish to take the time to issue a ruling that will say what will be disclosed and what will be kept private, because this court has a duty to do so, and I would rather do it right and take more time than to be rash and miss the mark. I need to be narrow in my approach, and it is an important issue, and so I plan to do that. In regards to the motion for limited intervention and request for notice of motions to close or reclassify, I also wish to craft my order in such a way that is concise and addresses all the issues, the important issues brought up by all parties. And so I will be issuing that at the same time. And so I will be ruling state's motion to clarify court's pretrial and trial publicity order, and I am prepared to do so. Before I do that, what I want to do is, and counsel is being caught off guard because they were anticipating a ruling today, but what the court is intending to do is, and proposing to the parties, is issuing an oral ruling on WebEx that all parties can attend to. The reason why is I don't want to take a lot of time. These are important issues. I don't want to wait until January 16th. And I want to talk about potential dates. I don't imagine it will take longer than 20 minutes for this court to issue a ruling. And I want to get the parties' input in regards to their thoughts of the court issuing an oral ruling on WebEx. And so I'll open it up to the parties.
We don't have any objection to that, Your Honor.
Thank you.
We have no objection to that, Your Honor.
Yeah, same.
Well, next comes the trickier part when you have a room full of attorneys trying to find a date that we're all available. What dates do we have available for a 30-minute block before the end of the year?
We got a lot of money to make, and we got to deal with this one.
December 29th at 10 o'clock.
I wonder if the WebEx is going to be public or
Does
private.
that date work for
It's
counsel?
going to be private.
That was 10 a.m. on the 29th.
Hello? Who shot Charlie Kirk? Another never-ending mystery. Welcome back to Mystery Tours, where we look at COVID-19, 9/11, JFK, and Charlie Kirk. What do all four of those events have in common? Well, you could say they were all manufactured incidences. And Charlie Kirk knew he was going to get his head blown off the next day. Hello?
Without counsel present.
All right. Thank you. I appreciate that. So we will set the court's ruling on those two issues for December 29th at 10 a.m. And note that it will be audio only for Mr. Robinson.
Audio
His
only!
request. And to the last issue is, well, before I issue my ruling, I anticipate, and counsel, are we still on the same page in regards to our January 16th hearing? Are we planning for that?
Your Honor, we are. We believe that most likely what we would anticipate doing is on January 16th, arguing our motion to disqualify the county attorney's office, which was just filed. That should give them enough time to respond to that. And also possibly we anticipate filing our own motion about the pretrial publicity order that has a little bit different take on it. That should be filed in plenty of time for us to argue that on the 16th as well. I think we have set aside the 30th, and that might be the one we want to save to argue our anticipated motion that's coming about keeping cameras out of the courtroom. And we will, I imagine the media will, depending on the court's ruling today, will want to weigh in on that one as well, and that would give them enough time as well. So that would be January 30th.
All right, and before I go to the other parties, the January 30th date, there was some complications, and so we have to find another date.
Okay.
And so I just wanted to let all parties know before we lock in our schedules, what dates do we have available for a 4-hour setting?
My problem.
And counsel, I appreciate you giving me that roadmap that helps plan, so it allows the other parties to take in consideration dates and filings as well. So as staff is doing that, they are looking for hearing dates. And one of the complications is, as a judge, I have 1,409 cases as of last Friday. And so trying to find a spot is tricky. And I'm grateful for my staff who work so hard to manage that calendar. So that is part of the reason for the delay. And we're trying to find a date because this is an important case, as is all of those cases. They matter to me.
Your Honor, while we're waiting, can I, if I might just make one point that might make things smoother as we go forward with sealed filings? Just to Ms. Nestor's point, Mr. Novak earlier mentioned something about a redacted motion to disqualify. And I don't know if that is something that they're planning to file, but I was just going to say sometimes, what we heard earlier about that particular incident is probably not something that we care that much about in terms of what they would redact. And so instead of opposing the motion to classify, if Your Honor, I don't know if this plan already in this case or whether that's what they were planning to do, but if they file a redacted version that, just takes out the stuff they care about rather than closing the whole thing, then we don't have to say anything and probably avoids, fighting over unsealing that document. So I just wanted to say that. I'm happy to confer with counsel if you'd rather us do that, if you don't want to do it by way of a court order.
No, I appreciate that input. I'll hear from both parties and then we'll get to the date.
Your Honor, I do anticipate going through and seeing what we can redact and working with the state on that as well, and with media counsel.
All right.
And we agree that filing a redacted version is a good way to go. We can work together on that. As far as the January 16th hearing, the state will do everything it can to respond to these motions as timely as we can, as expeditiously as we can. I just want to note that January 16th hearing was set with the expectation, the previous expectation was that defense counsel was going to get us these motions before Thanksgiving. And we just got the motion to disqualify last night. So we'll do everything we can to respond to those as expeditiously as we can and hopefully keep that date, but I'm not guaranteeing that we'll make that date.
All right. I appreciate the heads up. Going to staff, what dates do we have available for in lieu of the 30th? February 3rd, morning or afternoon setting?
You want that? That works for Mr. Robinson, Your Honor.
All right, thank you. And morning or afternoon setting?
Either works for us, Your Honor.
As well as for the state, we're available on the 3rd.
The afternoon would be better. Maybe that it reduces travel time.
All right. Well, it is always nice when all parties agree. So we have February 3rd at 1 p.m. It is anticipated to be in person. And Ms. Nestor, is Mr. Robinson planning on appearing?
Yes, Your Honor.
All right. Thank you. All right, that concludes that particular issue about future dates, and I appreciate counsel working with me on that. We have December 29th at 10 a.m. for the court ruling on these two issues, and that will be via WebEx. And then February 3rd, January 16th, I believe that is at 1 o'clock. Is that correct? All right, that's in person as well with, I believe, defense has indicated Mr. Robinson will be present as well. And finally, February 3rd at 1 p.m. and also indicating that Mr. Robinson will be present. And in regards to the final issue, the ruling on state's motion to clarify court's pretrial and trial publicity order. This is the order of the court. The court issued a protection order regarding pretrial and trial publicity in this case. The order prohibits attorneys who are associated with the prosecution and defense of this case from intentionally, knowingly, or recklessly permitting a witness, investigator, consultant, staff member, or other member of the prosecution or defense team to make extrajudicial statements which, if made by the lawyer, would violate Rule 3.6. To that end, lawyers participating in an investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams about the prohibitions contained in this order. The state moves to amend or clarify the court's use of the word witness as used in the publicity order because it is vague, ambiguous, or overbroad. The state asserts there are over 3,000 lay witnesses of the alleged homicide. The state does not know if it must inform each potential witness or each potential and possible witness of the prohibitions in order, or whether the order applies only to witnesses who are members of the attorney's teams, such as investigators or experts. Due to the potential confusion, this court grants the state's motion and offers the following clarification. The word witness, as used in this order, applies to all witnesses who are part of the prosecution and defense teams. This includes any witness, including lay witnesses, whom the prosecution or defense has a good faith belief will be called to testify at a hearing or trial. The court also clarifies that the publicity order as written regulates the behavior of attorneys who are associated with the defense team or the Utah County Attorney's Office. It requires the attorneys to abide by Rule 3.6 and, in order to deter non-attorneys from making prejudicial statements, requires the attorneys to inform witnesses about the prohibitions in the publicity order. Informing witnesses about the prohibitions in the publicity order is a necessary step. It is one moment as I regain my place as I read. Informing witnesses about the prohibitions in the publicity order is a necessary step toward not intentionally, knowingly, or recklessly permitting witnesses from making prejudicial statements. The publicity order does not regulate the behavior of any person who is not an attorney associated with this case, and this order will be signed today by myself and made public. Counsel, is there anything further that we need to address today?
Thanks, Your Honor. Yes, just the matter of having Mrs. Erica Kirk designated as the victim representative in this case. She has filed through her counsel a request to be designated as the victim representative, and we'd like the court to formally acknowledge that request and formally designate her as the victim representative. And I guess along those lines, I wanted to make clear as well, I think this court stated earlier that there was an alleged victim in this case. And I know that there is case law talking about being careful about how we refer to victims and alleged victims. But in this case, that case law makes clear that those cautions don't apply with the same degree, where it's clear that we have a victim who was killed in this case. We don't have an alleged victim. We have an alleged perpetrator, but we do know that we have a victim in this case.
Thank you, Mr. Ballard. I'll hear from the parties.
Your Honor, on behalf of Mr. Robinson, we certainly think it's appropriate for Mrs. Kirk to be designated as the victim representative, if that is the desire of the state, just so there can be no doubt that she's afforded all of the rights assured to her under our state statutes, and we have no objection to that.
Thank you. Thank you to all parties. This court will recognize Ms. Erica Kirk as the designated victim representative in this case. Thank you. Counsel, I believe that concludes our matters for the day. Or maybe not.
I can take the podium, Judge?
Yes, Mr. Reader.
The purpose, I want to just give the court an update with respect to discovery. We've done that at previous hearings. The state has received approximately 13,900 files from law enforcement in this case. Approximately 300 of those we believe are duplicates. We have since provided to counsel, as of I believe this morning, 7,951 of those files. For the court's information, we had reached close to 100% had been disseminated as of last week, but we received quite a large batch within the last few days. So we were working on that. We still have a full-time paralegal that's dedicated to reviewing that.
Full-time paralegal to do your job!
And sending it out to counsel. Of course, there are necessary redactions that are being made along the way. Our next real hearing in this case, second matter, our next real hearing in this case is not scheduled till January 16th. We understand the court's caseload. We understand the difficulty of finding dates for a preliminary hearing. And we would like to make a request that the court calendar a preliminary hearing in this case.
All right. In regards to, and I appreciate the heads up and acknowledging the busy calendar of not only the court, but all of you. What, first of all, how many days does the state anticipate helps us in our calendaring efforts?
Judge, given that it's a probable cause standard, and all the inferences go in favor of the state is asking for 3 days. We believe that we can present the evidence required to meet that standard, and that would also allow the defense to cross-examine witnesses and argue that standard.
Thank you, Mr. Your Honor. Turning to defense, what are your thoughts?
Your Honor, we were not aware that he was going to make that request today. We do have one more member of our team that's not present that we would need to consult with.
It's a big nothing
I don't know
burger.
when he's
It's going
talking
to be a
about,
big
but I
nothing
don't
burger
see how we
forever.
can set it
This is
until
all
all the
attorneys do.
discovery has been
They're
received.
essentially time travelers. They're time traveling
And also, we do need
hypnotists.
to deal with the default
That's what they do professionally. Just delay.
So it doesn't seem
Push,
like a
push,
good idea to set it before we have the disqualification
There's
hearing.
so
We're
much
only talking about a
information.
month from now.
You know how long
I
it
think
takes
that should
to
probably be resolved before we set
get
any
verbal information
dates.
into the record for these
But
things?
I
This
am
could go on
concerned about
forever.
setting a date when we still don't have all the discovery
Probably won't have a
materials. We have
verdict till
significant
like a year,
discovery
right?
materials that have not been received yet that we know are out there and coming and important, and we have to, have time to
And they're going to
review it
restrict
all and
all
absorb it all.
audio and video. I mean, this whole
And
thing is
I am
about
going to be
Erica
involved in
Kirk
another trial that is not over until
letting
the end
no
of
information
March.
come up.
So
And then
that's
people are
going to
just
take
going to
away
sit
my
there
ability to
and
work
hypnotize
and
themselves with
process
it for like a
through
year.
discovery and
But Chris,
communicate
I'm
with
breaking
others.
free again soon into the
So
book
it
club.
seems to me that with the understanding of what
I'm
Mr.
gonna
Granander
go
is trying to
full-time book
accomplish,
meditationist.
that maybe we come to the hearing on the 16th
Soon.
with
I
an
don't know
idea
when.
about
Shit is so
we can have
addictive.
some conversations with with Mr. McBride and also with the paralegal that's dealing with all the discovery and see realistically when we think we're actually going to have the vast majority of the discovery materials to us and how long it's going to take us to review it all. So maybe we could just come prepared in about a month to try to accomplish that.
In about a month.
Just 2 points, Judge. Sometimes I feel like we as practitioners sometimes lose sight of the purpose of a preliminary hearing. It is a probable cause determination. The primary purpose, according to case law, is to ferret out improvident prosecutions. So again, it's a probable cause standard. We are working as hard as we can, being very diligent with respect to collecting and disseminating discovery. Rule 16, subsection 2, speaks to the timing of mandatory disclosures, and it's a continuing duty. So as far as complete discovery being provided, in a case like this, complete discovery is going to be ongoing until probably trial. There are times when things become available during trial that are discovered to opposing counsel. But it says the prosecutor's disclosures must be made as soon as practicable following the filing of an information, except that a prosecutor must disclose all evidence that the prosecutor relied upon to file the information within 5 days after the day on which the prosecutor receives a request for discovery from the defendant. That's been accomplished. It then says, in every case, all material or information listed in paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary hearing. So we are in the process of that, collecting it as quickly as possible, making any necessary redactions, and moving it to the defense as quickly as possible. But complete discovery is not required before a preliminary hearing. we have to provide it as quickly as possible. We have that duty, and we continue to do that. So we think we can schedule a preliminary hearing and work towards that. I'm aware of Ms. Nestor's schedule. I know she's going to be in trial, I think, in February and March. And I'm probably overestimating the availability of the court's calendar, but the hope would be sometime in April to schedule a preliminary hearing. All right, I'll submit it, Judge. You.
Can I just clarify one thing? I mean, the county attorney has made a decision, a very public decision, to announce their intent to seek death the day that there was an arrest, which means that that obligation to provide us with the probable cause for everything they relied upon to charge applies now to their intent to seek death. And we're nowhere near getting that material. So that was their decision to release that. Normally that decision is not made until 30 days after a preliminary hearing. They made it in advance, and now they've got an obligation to tell me their aggravation and what they've relied on to make this a death penalty case. And we have not received that. So I'm waiting, but I'm just laying that out there for now.
Thank you. I appreciate the arguments from all sides. I do not find there is any prejudice in setting a date for a preliminary hearing. It is not set in stone, and it certainly can be moved. I recognize that the parties have a lot of obligations, but I also recognize the importance of this case moving forward, and if nothing more than this is a goal for the preliminary hearing. If it needs to be changed, the court understands that. That is what happens a lot in the criminal calendars and criminal dockets. What is a date that we may have available for a 3-day setting for a preliminary hearing?
Judge, the first week that we would have available is the week of May 18th. We do also have a week of some days in June, and there's not people on May. We do not have them in July. We have several August.
All right, let's take a look. So, council, well, what dates in June?
June starting on the 15th.
Your microphone's very quiet. It's not the audio.
To you, again, this is a goal. This is not a date that if we can't meet, there's any prejudice that will be attached to a party. In regards to May 18th, how does that tentatively look for council?
May or June?
May 18th is the first date, I believe.
Oh.
So 18th, 19th, and 21st, just to give you the full range.
The state can make those days work, Your Honor.
They're just checking their calendars. Your Honor, we have availability the May 18th with the understanding and the appreciation that if it's not feasible for us to get done when we need to get done prior to that, we would ask to push it back. But we don't have conflicts at this time.
All right, thank you. So May 18th, May 19th, and May 21st. And it will be in person. And do we anticipate, if that date moves forward, Mr. Robinson being in attendance?
Absolutely.
All right, thank you. I just want to put that on the record as well. All right, I don't want to be presumptive, but is there anything else? All right. Council, thank you again for your hard work today. And I wish you all, Mr. Robinson, a good afternoon. Court is in recess.
Thank you. Thank you. And that's it. Court is in recess.
Okay, yeah. So very interesting. I thought it was very interesting that they are going to let Erica Kirk be a party in the trial. Because if I'm correct, usually the victim is behind the prosecution. right? So, and it's usually, if I'm correct, it's usually the prosecution's job to make sure that the victims are fairly represented throughout the process. It sounds like she's inserting herself into this trial, which is fine. Obviously, she has the most interest out of all parties to see that there's justice done here. So I am not disparaging her at all for that. Just like from a legal standpoint, I just thought it was an interesting turn of events. This whole thing with the closed session and, these motions that are filed, like there was a motion filed last night by the prosecution that was done in secret. And that's what they're redacting, right? Like, what's going on there? Like, why are they stealing or editing out certain portions of this trial to the public? And what's even more interesting to me is that Tyler's attorneys are on the side of removing the cameras from the courtroom. They don't want this publicized for some reason. It even sounds like the state is not interested in having cameras in here. The media has their own lawyer. There's like 10 media groups, some smaller stations, and like CBS and Fox and either Newsmax or News Nation, I think. One of them have all formed this kind of third party that is suing the court to be considered an actual party, so that way they can make sure they can contest any sealing of documents or closed session hearings or anything that might be a restriction on public access to information, as well as having cameras in the courtroom. So that's one of the things that was presented today, and the judge is going to rule on all of this through a WebEx hearing, which means it'll be done online, it sounds like, on December 30th, so just before New Year's. So that's kind of crazy timing. And then they're going to be back in courts for the actual first pretrial hearing, which will be on this January 19th. Obviously, this is going to take a while. You heard them say that there's so much discovery, and because the prosecution moved so fast for the death penalty, there's a dispute on how much time they should have to present evidence that this is a capital punishment crime, that it meets all of the qualifications, because they declared that it was a capital punishment crime before they had collected all of their evidence. So they're trying to limit the scope that the prosecution has to collect all of that information and use it in trial. So they set that for June, right? So like that just tells you how long this trial is going to take. We're looking at the middle of next year for the cap on discovery so far, and they're actually having a hearing to make to litigate that. So that means that the scope of this trial is massive. You heard what they said about the witnesses. I think that was an important clarification as to the gag order today. They said that as it pertains to the case right now, only attorneys and people involved with counsel are really under the gag order at this time. And key witnesses need to be notified if they are determined to be under the scope of the gag order. So technically, key witnesses could be out there in the public, and they even said until it becomes a problem, they didn't feel like it was necessary to really litigate that. So that they thought that they would have to come in and litigate it later on when it does become a problem. So I thought that was very interesting. So that means you could technically interview a witness. From what I understood, and maybe I'm wrong, we can look at it, but it sounds like witnesses could give statements. And if that's so, I think it's very interesting that we have key witnesses that were there giving public statements about their testimony, like Blake Neff, for example, publicly using Charlie Kirk's platform to convey information, but we have zero witnesses from the Robinson family or anybody else on his side also airing what they witnessed publicly. Like, why is that? That seems a little unbalanced if we're seeking justice. Very, very interesting turn of events. Grok, did I get my interpretation of the gag order segment accurate?
Yeah, you nailed it almost perfectly. The judge clarified the gag order today, like this. Only the lawyers, prosecution and defense, are actually gagged. They have to warn their own team members, investigators, staff, consultants, and any lay witness they have a good faith belief they will actually call to testify. Hey, don't say anything that would violate Rule 3.6. If a lawyer said it. Regular people who might have seen something, even important things, are not gagged unless and until one side decides, yep, we're definitely putting this person on the stand. So right now, random neighbors, party guests, etc. can still talk freely. Only once the state or defense tags someone as, we're calling you, does the lawyer have to notify them and bring them under the umbrella. That's why the judge said, we'll deal with it if it becomes a problem later. Translation, witnesses can give interviews today. And nobody's technically violating the order unless the lawyers already know they're going to call that person and didn't warn them. So yeah, your read was spot on. Blake Neff or anyone else talking publicly right now is fine under this order, unless the state has already internally decided we're 100% calling him and forgot to tell him to zip it.
But it only counts against it only holds water against the witness if they have been notified by the courts. Correct?
Exactly. Nothing in that order punishes a witness directly. The only one who gets sanctioned is the attorney, if they knew, we're calling you, and never told the witness to stay quiet. So if Blake Neff flirts tomorrow and nobody warns him, he's fine. The lawyer's the one in hot water, not him. Court can't touch the witness unless there's a separate, broader gag on the books. Right now, it isn't.
All right. Thank you for that, Grok. Bottom right corner, everybody repost the space. We're going to get into this. Slick
What's
Dog.
interesting, Diligent.
Go ahead.
Really quickly, what's interesting about you were mentioning that the defense, and that is interesting. Although I'm not surprised. Defense kind of is leaning against wanting cameras. Prosecution's maybe a little more, maybe also skeptical, but not as skeptical. But what's interesting is that Erica Kirk has come out repeatedly, publicly in favor. She said that she wants everything broadcast to the public, so that because her rationale, which makes sense, is Charlie was murdered obviously publicly in front of thousands of people in person and millions at home. And so that the evidence should be broadcast so that people believe that justice has been done.
And I agree with that. You are right. She has come out and said that, and obviously she feels that because I know that during these investigations, detectives and prosecutors often share information with the victims in these cases, and as Charlie Kirk's wife, she is considered a victim. So it doesn't surprise me that she would be looked at as a party. I'm just wondering what that means. You know what I mean? Like she asked for explicit representation through an attorney to represent the victims in this case, and I'm just wondering how much impact that has on the judicial process. And Slick Dog is my resident legal nerd. And so, Slick Dog, did I interpret the events today accurately, would you say? And can you elaborate on Erica Kirk's role in this trial going forward now that they've deemed that she is a party as the victim's advocate? Slick Dog, are you there? And we lost. Okay, maybe I'll have Grok answer that real quick. Go ahead, Grok.
She's not a party like a prosecution or defense. Think of her as the voice in the room that makes sure victims aren't forgotten. Utah law lets one family member step in like this, get updates, submit impact statements, even suggest things like restitution. She can't call witnesses, file motions, or argue law. But if the court closes doors or seals records, she'll get notice.
same as the media, and can object. So her power is limited, but symbolic. She's there so judges remember there's a human, not just charges. That matters when death penalty's on the table.
I think that they have to also go through her if there's going to be a plea deal or if they're making any arrangements with him. It all has to be ran through her. Slick Dog, are you there?
You like they did for the guy who beheaded those 4 college kids up there, right? You guys remember that? There was a guy last year or was it this year? It may have been earlier this year. There was a guy who beheaded, and I mean beheaded, 4 college students. And
was that in Idaho?
I think it was in Idaho, yeah. And yeah, it was actually. He beheaded 4 college students, and the prosecution and judge let him make a plea deal for life when it was a capital punishment case without referring to the victim. Completely fucking illegal. Completely illegal. And disgusting, if you ask me. Go ahead, History.
She won't sit with the prosecution, though, because you had originally said...
No, they always sit in the pews.
She'll sit behind them, right? Correct?
Yeah, in the pews.
Okay, that was just my clarification. And I also found it really weird that he was able to, as in the judge, so they came in, so I don't know if I'm right or wrong on this, that's why I'm glad Slick Dog is here. That judge read, so they went ahead and did both their briefs and what they were trying to argue, their arguments, and right away, he made a decision. It was I'm sorry, maybe it just came across to me like... What
do you mean? What did he make a decision on?
So she had said, even about the preliminary dates and stuff. And what she said is so true.
I mean, the date was already set, and it was something that was agreed on by all
parties.
No,
the one for June or May. The one for May.
Yeah, that was just them. He was looking for common ground. If nobody's in objection on the dates, I don't see why that's a problem.
Okay,
if all parties are in agreement on scheduling the date, what's the issue?
Okay, but even his reading of what they were arguing even in the beginning.
Well, hold on. Let's we got a Slick Dog up here.
Okay.
He's an attorney. Let's go to him. Slick Dog, were you able to hear what I asked you earlier? Can you?
Yeah, I was on 2 things. One, just to remind everyone, I know I've said this before, but the so-called the gag order is really just putting in the form of a court order what is already existing requirements under Utah's Attorney Rules of Ethics. So these rules already exist, and so I think what the judge has done is just put a fine point on that, and which makes sense because the way that a lay person reads it is it's overly broad, and I've read the existing order that was issued back in September.
Is my interpretation of it accurate?
It is. Yeah, I think it's accurate. Yes, and it really and what the judge has just done is put a fine. But it was it's still the same. It is an attorney rule of ethics. An attorney. I mean, even if, as long as the attorney has notified the witness or the other party, then they've satisfied their obligation of the Utah, code of conduct for attorneys, rules of professional conduct. They obviously can't control them, but as far as the actual witnesses, once they're subpoenaed and are obviously parties to the case, then they are subject to the gag order as well. As far as Erica Kirk, I don't know what the actual role in Utah is for a victim statement. I mean that is common, I know, in Maryland.
Usually reserved for sentencing, right?
Yes, and notice of filings. But I don't know. I mean that would put her. They would have to prosecution would notify her as
of the requirements of the pre-trial publicity order. In terms of the preliminary hearing going way out till May or June, wow, that's significant. I will. I have not, added any new filings to that shared folder that I had sent to you and Noxie.
I admit I haven't had time to go through it.
I really encourage you to, and it's easy to dismiss the folder with the, on the appearing in civilian clothing, but there's a lot there. And I will go back, it's not going to be to the weekend, but I encourage you to read all that if you want to share it with the
Can you weigh in on the closed session and the midnight hour motion filed last night?
I can't because I haven't seen them.
But can you just kind of elaborate what that is? Did you hear them discussing that in that clip?
I heard it for the first time as you, so I didn't know about it. I haven't logged in to the docket to see any recent filings since Thanksgiving. So, but I will do that in the next day or two. And I think, despite what we hear or we think what we hear in the hearings, from my point of view, I want to see what did the actual motion say, and how has the judge, what has been the response from the court in terms of issuing an order. It is a busy docket, and again, I personally do not see any, indication that Tyler Robinson is getting, inadequate counsel or anything but a robust defense, and that's just, what I see. Go ahead.
No, I was just going to ask you, is it normal that, he hasn't even plead yet, whether he's guilty or not guilty? Is it normal for somebody
That's
to
the arraignment process, yeah. Why has he been arraigned yet?
Yeah, I mean, in Maryland, I know, we have a speedy trial provision. Well, this would have to get done in a certain number of days based on the offense. So that's why I was surprised that the preliminary...
In Utah, the preliminary hearing is where he actually says guilty, not guilty,
right,
etc. So that's January 19th.
I thought the preliminary hearing, But
it was the defense that asked. I think the reason why is because it was actually the defense that requested the delay for the preliminary hearing because it got delayed. But I believe it was at the request of the defense because of the quote-unquote voluminous amount of evidence that that they had to go through from the packet from the prosecutor, if I remember correctly.
Right, and that same statement was made at the first hearing back in October. So and so on the one hand, it's a probable cause hearing. The state has enough to satisfy to present for that probable cause preliminary hearing. And on the other hand, I thought I appreciated what Attorney Nestor said for the defense that look, the state jumped the gun when, on day one they said they were going to seek the death penalty, when usually that is something that isn't made until after. So now they got to live with it.
And what implications does that have? From what you heard, does that mean that they have to meet that criteria by the deadline for capital punishment? Otherwise, it's off the table. It sounds like that's what the implications are.
No, I don't think that changes. There's a difference. Are you saying so? There's the burden.
I feel like that's what the defense asserted was. They started the discovery clock when they for capital punishment because you have to prove that the case meets that criteria to have that charge stick, right? So
right. So
it sounded like she asserted that the timer started going off on day one when they said they were going after capital punishment. And
right.
That's what the May or June deadline hearing date was for, if I remember correctly. And we can have Rocco get up by statute if we need to.
Yeah, I would actually like to hear Brock thinks about what the timing is. So what I heard the defense say was that typically, the state doesn't, make a pronouncement that it will be seeking the death penalty until after 30 days or until after the preliminary hearing, one of those two. But in this case, they did it in day one. There was probably some type of political pressure to make that grand announcement. And because it is a death penalty case, the defense wants as much time as possible to do what it can to review discovery, to put up a defense. And yes, that accounts for a longer delay, but it would give them, more time to, mount an adequate defense. And this is mounting the defense just at the probable cause hearing. I mean, we haven't even talked about trial yet, about any pre-trial work. So
she also Grok. Hold on, I'm gonna have Grok weigh in on the capital punishment and discovery timeline. Grok, can you explain that, and can you cite the statute so that Slick Dog can try to interpret it for us?
Here's the exact Utah law on when the death penalty notice must be filed and what it triggers for discovery. Utah Code 77-18-112. Notice of intent to seek death penalty. 2. If the prosecutor files a notice of intent to seek the death penalty, the notice shall be I. Filed no later than 60 days after the defendant's arraignment on the information or indictment, or I. If the defendant waives the 60-day period at any time before trial. Utah Code 76-3-207 WFC. Capital procedure. In every capital case, the defendant is entitled to 15 days after arraignment to file motions, and the prosecution must provide all discovery at least 30 days before trial, unless the court orders otherwise. Key points for this date. 1. Tyler Robinson has not yet been arraigned. That's scheduled for January 16, 2026. So the 60-day death notice clock hasn't even started yet. 2. The prosecution already announced publicly and filed their notice that they intend to seek death before arraignment. That's allowed. The statute only sets the latest date, 60 days after arraignment, not the earliest. They can file it day one if they want. 3. What the defense was arguing today, and Nestor is 100% correctly pointed out, is this. By jumping the gun and filing the death notice immediately, the state triggered the capital case discovery and preparation rules much earlier than usual. In a normal capital case, the state often waits until after the preliminary hearing to decide, which gives the defense months of breathing room. Here, the defense is saying, you declared it capital on day one, so you don't get to slow walk the aggravators, mitigation discovery, or expert funding now. Give it all to us ASAP. 4. Bottom line, the May-June 2026 preliminary hearing date is not required by any statute. It's just the court trying to move the case along. State versus, we're drowning in 14K plus files, and you made it capital immediately. Defense. So the defense didn't invent a new rule. They're just using the state's own aggressive death notice timing against them to buy more prep time. Totally legitimate strategy, and the judge basically said, fine, we'll set it for late spring, early summer.
That actually makes sense. Look, Dog, do you concur? Probably a mute glitch. Sorry about that. Just making sure AB didn't walk all over us. Go ahead, Slick Dog. Unmute your mic. Is it still mute glitched? All right, go ahead, AB, while we're waiting.
Yeah, no, just super quick. I also noticed that the defense lawyer mentioned her intention to file, I think it was a disqualification motion to maybe get the whole case thrown out. I'm guessing that's what that is.
That's the one that's redacted. That's the one that came in late last night. But that's a motion to dismiss, isn't it? Wouldn't it be described as such?
Well, she called it
disqualification is of evidence or a witness or
maybe that's what it was. Like that she mentioned the word the term disqualification motion, I think.
It could even be disqualification of an attorney. Like I think that their disqualification can apply to many different. Go ahead, Click Dog.
That's what we asked.
Hold on.
Hi, I'm in fighting with my mic button for some reason. I think that Grant gave an excellent summary. That was helpful to me. And strategically, I think the state kind of blew its wad early and giving the defense, an argument to demand, a good case to demand more discovery.
And what about that last point about what AB and I were discussing? I fucking forgot.
Oh, the disqualify the county. I don't know about that.
The disqualifier. So what does that language mean, though? When you use the word motion to disqualify, what does that usually apply to?
It sounds like they're trying to remove one of the attorneys. I don't know why. I mean, the first thing that comes to mind, it may be similar to what happened with the prosecutor in the Trump case. That was in regards to how the attorney was appointed. There could be a conflict of interest. Maybe that there's something that is disqualifying. I don't know what that is, but I found that to be one of the most intriguing parts of the case, and I want to pull the motion to see what the
it's going to be redacted. It hasn't even hit yet. Did you hear that?
Well, I want to say I don't know what's going to be redacted and what isn't, so I don't want to. And like a lot of things.
Well, they did say some of it was going to be redacted from based on what we heard.
Right, and I'm also interested in what the substantive legal argument is. If it's just redacting specific details, that's fine. But if it's because of inappropriate conduct or a conflict of interest, or
it's already getting spicy, and we haven't even started yet, Slick Dog.
I know. Oh, it is getting spicy. That's why, again, I am not troubled at all.
Should I just move to Utah for next year, or?
Well, you want to be careful because you want to monitor the court, the docket carefully, because things are going to get pushed back and dates are going to get switched. But what I want to do, and I'll start this weekend, is I want to beef up the files that I had sent you, and I encourage you to go through and read them. It's there's
we can do like a nerd interactive session where I do a video screen share space, and we can call I'll do like one of my R&D spaces, and we can pour through them together.
And I would invite any other attorneys that are on the call to kind of dig in and read through them and offer their input as well. I can certainly pull the documents. I can, understand what the issues are, but in terms of interpreting them under Utah law, I'm not going to pretend to be able to do that. But certainly there is.
I have another question. Is it normal for judges to have to go back to their script before they can continue to respond to somebody like that?
I heard you say that. You said that he was reading from a script.
Well, I posted that. I said, is anybody not reading from a script here? And then some jackass in the comments is like, how do you know he's reading from a script? And I'm like, I guess I can't actually prove he is, but then towards the end of the hearing, he actually said, oh, hold on, I almost I had forgot to be reading from my computer before I responded. So he had actually interrupted himself so that he could go back and read the words from the screen. So is that normal?
In a case like this, I don't know. I mean, I think that, a judge could lose he lost his place reading his own order, which I found.
That's crazy.
And so my first reaction, and I'm not saying this is the case, was who the heck is his clerk? That his clerk posted something, maybe it was in a red line format or what hadn't been finished yet, but that he lost his place reading his own order was just I could not understand that. It did not occur to me that, he's reading from a script until you said it. I doubt that's the case, but who knows?
I mean, he's reading from his screen more time than he's not. Like, so I guess you can, maybe I'm being a little hyperbole there. You know, I am being a little hyperbolic, right? By calling it a script, because, you know, that would imply that he's an actor, or reading from, you know, somebody else's whatever. But I mean, when he actually lost his place because he wasn't reading from the screen and he had to go back, I was like, oof, that's that actually just kind of just affirmed my assertions. So
I don't think it was a script that came from the deep state that this is what you're going to say.
I didn't say that. It's not my claim.
Okay, all right.
Although he was disappointed, okay, and this is his first murder trial ever, and he's just a brand new judge, just a couple of months on.
That probably explains why he's reading from a script. He wants to make sure he's buttoned up and gets everything 100% correctly.
And I have one more question about the back and forth between the attorneys, and then we'll go to the hands. And of course, anybody can ask slick jog questions. But is it normal for attorneys to instruct the judge on how these procedures are going? I've noticed that with particularly the prosecution, it seems like they're instructing the judge as to how this is supposed to work, instead of the other way around. Am I reading that off?
No, I mean, I think that there's a dialogue, so it's not set in stone, and so that didn't surprise me. I thought, you know, he was very cordial.
Am I wrong in my perception?
No.
Okay.
That is your perception. So.
I know, but is it accurate, right? Like, am I biased? I'm skeptical. I don't know what's going on with me, but ever since July, my skeptics lens is dialed up to 5,000. Over 5,000. You can quote me.
I think that, I mean, in my experience, you know, is that, you know, the court, I mean, there are rules of procedure, criminal procedure in this case, that need to be followed with certain dates and timelines. But then there are also, you know, a judge likes it when both parties can agree, say, to calendar dates, or to, you know, if there is a stipulated motion where both parties agree on an order, and so that they don't have to fight it out in front of the judge, everything that they can agree ahead of time. So, for instance, there is, you know, in most states, the timeline differs, that within so many hours before filing a motion, the party is required to send a copy of the motion at least 24 hours or 72 hours in advance to the opposing party and ask if they have any objections. That allows both parties, if there is no objection or only, you know, a slight objection, the two parties can come together and agree and work together to craft an order and then present that order to the judge, and the judge will sign it. So the one thing about the pretrial publicity order, also, you know, what people are calling the gag order, is that was issued sua sponte from the court, so that, you know, without prompting. That was a court issued, prompted, you know, from the bench. That was not requested by either party. After he issued it, then the defense made a request for modifications, and the judge granted that request, but did so without giving the state the full amount of time for them to reply to the modifications that the defense had asked. And so the original the order granting defense's request had to be set aside until both parties could argue it, which they did, and then the judge issued his order today, which he read, and we'll see in writing. You know, in terms of, I don't think that I'm in a good position now to be peppered with questions. But
That's fine.
Yeah.
I think I've extracted the questions I needed out of you anyway.
Okay. What I think I can contribute is, you know, this weekend is let me beef up the folders. They're in that Dropbox account that I'd sent, and then if people want to be
I'll try to find some more socially extroverted attorneys to come up and.
Yeah, I would really like to hear more, and I can keep on top of the docket, and when there's a new filing, just let you know during a space and talk about it. But certainly, whatever, and it's going to take me this weekend. I'm buried with my own work right now, but. I think that would be a good way that I can.
We really appreciate everything that you're contributing, especially the docket downloads. That's amazing work. Thank you.
My pleasure.
Let's go to Penny.
All right, Slick is awesome. Thank you. I wasn't really paying too much attention because I'm working at the moment, and it just sounded like a boring court hearing, quite frankly. But no, I understand what you're saying in terms of the scripts thing. You're right. I mean, at the beginning even, and I remember in his last hearing too, it's like he wrote something, or his clerk did, or someone did, and he's reading it line by line. And I've seen judges read like their orders, or say some sort of procedural memo just to get the points across verbatim. So it's on the record one, even though I'm sure he's going to do a minute entry. But so generally, if like the lawyers have like paralegals or something, they can write it all down really quick, or do some sort of dictation. So my thought is he's new. I mean, maybe he's really nervous, right? It just seemed he did not seem confident. And like you said, there was the banter back and forth, and that generally is normal.
Very tofu sounding, Judge. No offense to him. All respect to his honor, Your Honor, but very tofu.
I kind of thought that too. I was like, he doesn't really seem like that's not who I'd expect in Utah. But yeah.
He's a brand new judge. Maybe that's a lot of it. And people were putting in the comments, they're like, maybe they're offering more suggestions because he is a new judge. I have another attorney from the region who added a comment below, one of my subscribers. He said, if the judge is new, they can give suggestions, and that's what he was interpreting it as.
That's what I thought too. I just find it strange, and again, I don't know how Utah works, but how this particular judge got assigned to this case. I mean, I don't know. It works differently in every state, but he seems a little bit out of his element. That's just my opinion. So anyway, yeah, I just want to let you know, you're spot on. Yeah, it seems a little strange. So I'll land.
What do you think about the closed session?
I think I've had that type of issue come up in cases not even close to I don't want to say important, but as
public interest.
Thank you. And dramatic, right? I've had this happen in cases that, literally it's a bad faith insurance case where the insurer or the insurance company basically put their own interests before the insureds. And we've had closed sessions on that. So I'm kind of wishy-washy on that. I do think there's a major First Amendment issue here, but I understand the balancing of the interests of the right to a fair trial of Tyler Robinson, but I don't know. I don't know. I'm trying not to read too much into it, but I just want to let you know, I've seen it in cases that you think, why is this a closed proceeding? And it's just, it happens for different reasons. So it's not completely out of the ordinary, and especially in a case of this high profile. So.
All right, thank you so much, Penny. Go ahead, Trillian.
Hey, what's up, guys? So I looked into the disqualification thing, and so typically it is used to disqualify an attorney or something. But Grok actually said that this was the hearing for disqualifying or limiting media access in the courtrooms and the cameras. So I don't know if it pertains to that, because that makes more sense to me why they threw in, let's make Erica Kirk the victim representative, because they'll get rid of the cameras, or so let's say they don't have any cameras in there, but they have Erica, in the room grieving and weeping the entire time. So basically, I could see how they could potentially use that as a tactic. So it gives her a way to like always be in the room. Nobody is watching it because all the cameras are barred. So I think that's why his attorney said, well, you know what, it's not that we're against it, but let's see what happens with the camera thing first, because we basically don't want to just give Erica Kirk an opportunity to sit here and just like weep on camera in the courtroom the entire time. So I don't know. She does to the point that Slick Dog made, is like his lawyer does seem to be kind of all right. Like she seems like she's taking care of him, or at least given
I don't trust the state supplied anything.
Well, that's what's crazy, is she gonna rug him at some point? But like so far, it seems like she's putting things together.
I mean, but we're not even at the trial period, right? Like it's not even close. So it's way too early to determine whether or not he's getting fair representation. But about it, I can tell you this much: his grandmother was concerned about him getting fair representation.
I would be too. I've talked to the parents have not been.
And you know what? Now that I know that about the gag order, guess what I'm going to be doing? I'm going to be going to talk to as many fucking people and investigate this case as fully as possible. Now that I know that there's no gag order on the witnesses, my ass is going back to Utah and talking to as many people on camera as possible, so we can get a better accurate depiction of what's going on here, not from these talking heads like Jack Poso and the rest of them.
I don't know if you talked to this guy yet, but I have someone you might be interested in. So it's someone who works with a friend of Matt Robinson's brother, who happens, I guess the brother of Matt Robinson happens to be in the DEA or something. But, I mean, I'll send you the contact, man. I don't know if he's in Utah himself, but nobody's speaking to Matt or the mother. The closest we've gotten to is Matt Robinson's brother. So,
can I say quickly, after the initial arrest, maybe when I was on your Spaces a few months ago, I did a deep dive into the background of his lead attorney. She's very experienced, and she's been a defense lawyer her entire career. She's never been
She's been a federal court-appointed attorney almost her entire career.
Yeah, public defender.
So she's a part of the system.
Sure, she's definitely part of the system, but she's always on the defense side. And I've met a bunch of, because I have a lot of lawyers.
And what is the win rate in federal cases?
Cash
I agree with that.
Patel was also a court-appointed attorney for most of his career before.
No, but he's been on both. He's worked. I'm just saying, it is precisely the type of background you want. Like, not a newbie. You wouldn't want a newbie public defender for
He's
sure.
worked for the team that loses 98% of their cases.
That's the defense in general. That wouldn't matter whether he was getting a Johnny Cochran or a public defender, right? But the point is, she's super experienced. She's been doing it for well over 20 years. She's
Tell O.J. Simpson that.
Sure, that was a very one of a kind case for a lot of reasons, but it doesn't affect the overall. Most people who get prosecuted
this is also one of a kind case in and of itself as well, right? Like this is.
No, I agree. But I'm saying that had the racial dynamics for sure. All I'm saying, and you don't have to take my word for it, but
it's scary that the prosecution is asking him to make unprecedented decisions. Did you hear that in one of her final arguments? Because that. If they're asking for precedent, the increases. If I understand correctly, if he makes decisions that are based out of precedent, and if they are really like a new scope of law, the likelihood of it getting challenged or overturned or appealed, or even appealed later on, increases because they're not going through established precedent. So I feel like it's interesting to me that the prosecution would ask for setting new precedent when that might actually affect her case later on down the road.
What's the new precedent? I might have missed that because I didn't listen to the whole hearing.
It was I believe it was about the scope of the. Well, it was weird because she actually addressed two things. She addressed the scope of the gag order and also the media's role as a party to the case. And I would have to go back and listen to it, but it sounded like she was trying to have him, designate the scope very granularly as far as it pertains to the gag order. And I may be wrong. I might have to go back and listen to it again. But it doesn't matter either way. She did ask him to set.
She being the defense lawyer?
She was the prosecuting attorney.
Oh, got it. Yeah, I might have missed that part. All I wanted to say, just concluding on his lead, he has two attorneys right now. He has this woman who's like the lifelong public defender based in Utah, and
he has three attorneys.
Oh, maybe even three. Yeah. Then the one that was based in
lifelong
California.
Public defender, and then two attorneys from California that were on the Menendez brothers case.
Yeah. Oh, yeah. Exactly. So I looked into especially those two, but especially the public defender, the Utah-based one. And because I remember it was when we were talking about it months ago. She got a super long history, always the entire career, never been on the prosecution side, and she's defeated. And I asked Rock about this not now, but a couple months ago. She's defeated government. She's worked capital murder cases before. Anybody who's dealt with lawyers and stuff before.
And she didn't outright defeat them. She ended up getting them not being killed. I think that's a good distinction to make.
Yeah, I mean that is defeating them on at least on part of what they're seeking, And like you guys have said, and accurately, the win rate, the conviction rate for federal prosecutions is like 97, something crazy high. Especially it's higher in America than in other Western democracies. But she is precisely these types of people. I don't know about her specifically, but these types of people tend to be fanatically pro-defendant, usually far left politically. Not that matters so much, but the point is their point of view is always pro-defense. And they're, they want to basically they have your kind of point of view on the government. Even though they're paid by the government, they tend to have your point of view on government's always lying.
Justice warriors.
Yeah, they're SJW, and that's the kind of person.
Wait, hold on. That's not my position. My position.
No, you're not an SJW. You're not an SJW, but I'm just saying.
No, my position is not the government's always lying. My position is that the government should never be taken at face value.
Fair enough. I by the way, I agree with that. Generally agree with that too. But the point I'm trying to make is that's the type of person, if you're on trial for murder or for any serious crime, and you want that type of person who has experience and who has defeated the government in the past and who's only been a defense lawyer, that's the kind of person you want defending your ass when they're trying to kill you, obviously.
Right on.
Well, if that's the case, the judge has only been on the prosecution side before until he just got appointed as a judge.
That's true. That's true. Yeah.
Yeah. How do you get a balanced approach there? Weird. Very weird.
That is common though. A lot of former prosecutors become. I'm not saying it's good or bad, but it's very common for people who are prosecutors to be appointed to the bench. Yeah.
Okay. Go ahead. Luke.
Yes. I have been dealing with a case in Arizona which is controlled by Mormons, where all the rules of fair due process were thrown out. No right to a speedy trial, no Sixth Amendment right to defend yourself, illegal sealing of the case, court cases run in secret. Are you seeing some similar themes here to what Tyler Robinson is getting? Hearings are not meant to be done on Zoom, so the respondent can be shackled and muted. Hostile counsel appointed against the respondent's will, and the victim getting paid victim's compensation for being a Class 6 felony nurse imposter, as admitted by the prosecution and the nursing board, not me. Search my timeline for victory, you'll see the documents from the nursing board. So I'll start, prove the Mormon connection first. Armand Barker is won the election by 1% for Flagstaff, Coconino County Attorney's Office. He only gave interviews on his election campaign to Dave Zorn from CAF News. Flagstaff is like a Democrat stronghold in Arizona, and all judges in Arizona must be Democrat because azcourts.gov/J&C chooses the judges, and it's chosen by a panel of 33% independent and 33% Democrat, and the rest Republican. So that's why literally all the judges in Arizona are Democrat. And the judge, Joshua Steinlage, is an activist judge. He's hooked up with Lesbian Lombardo Legal for gay rights, and he's also on the Arizona Rule 11 Supreme Court Task Force, where he's recommending that Arizona Rules of Criminal Procedure 6.1 be changed so hostile counsel or counsel can be, you have no right to defend yourself. And just today in court, he says, I make the law, not the lawmakers. I don't follow rules of Arizona criminal procedure. Only a quorum from a grand jury can seal a case. The case was not sealed, but you cannot look up the case of Adam Alistair Woodward Smith on eaccess.azcourts.gov, but on the public access website, apps.azcourts.gov/public access, if you type in Adam Smith and choose Coconino County Superior Court, you can't put his birthday in because they changed his birthday to make him 200 years old. So if you've got to choose Coconino County Superior Court Adam Smith, you'll find the case. He's been held for 3 years. You have indefinite detention in Arizona with no right to a trial. He was previously found competent for trial by the 2 psychologists. There's only 2 people who decide who is competent in Flagstaff, Dr. Deborah Pardee and Dr. Wayne General. Wayne General said if you do a Roman salute, that's grounds to deny a trial. If you say your former lawyer, Adam Zickerman, was a pedophile rights activist, that's delusional. But he was in the Washington Post in the case of Samuel Rappertree Bateman from the fundamentalist sect of Latter-day Saints, Mormons. And Zickerman said the whole case against Samuel Bateman is religious persecution. That's 2 weeks after the FBI indicted him for having sex with his 9-year-old wife. And Zickerman, after doing that, was successfully nominated to become a judge by that J&C committee. And as well as being an activist for intergenerational child sex, he ticked the DEI box on the form to become a judge. He chose race Caucasian, but he ticked the DEI box and he said, because the pain of the Holocaust followed the sperm from my father into my mother's womb.
Are you talking about the current judge in this case?
Yeah, current judge. Joshua's...
I want to reel it back into Charlie Kirk, though. I think we're getting off into the weeds.
The Mormons are doing all the dirty tricks to not deny a trial, and there are Mormon links to this. So the prosecutor...
There are Mormon links to this, but are they linked to any of the parties in the case, like the judge, the prosecution, the defense?
A lot of people think that Tyler Robinson, now that he's got counsel, can be pushed into the background, and even if he wants to speak, he cannot be afforded the ability to do so. You have a Sixth Amendment. The Arizona Rules of Criminal Procedure says at any time in any proceedings, if they move this into a mental health situation, like with Arizona Rules of Criminal Procedure 11, it can drag on indefinitely. Okay. And that's something you could potentially look forwards to. The clock that they have, it just freezes indefinitely. And Adam's cellmate was swatted by his landlord, Howard Settler-Lenthal, who pled guilty to raping a 14-year-old girl and got 0 days jail. He was just illegally removed from the sex offender registry without due process in Arizona, without any court motions. You can compare it. And then
the cases in Utah.
Yeah, I want to reel it back in. I realize that this is important to you. I realize that this is important to you and what's going on in Utah, and it is interesting. I want to keep it on topic. So we can definitely keep our eyes peeled for the Mormon link within the parties in this particular case, but I do want to keep it on the subject. So, all right, thank you so much. Let's go to Catherine.
Thanks, Diligent. So when Slick Dog first started in the space, he was talking to us in a couple, I don't remember, maybe last week, the week before, he had talked about that it was kind of unusual for the sheriff's county to file a document, I think, or I don't know if it was a document or a motion. I put this in the purple pill, but after they talked about the schedules and stuff, I think it was someone from the prosecution side that came up. But they started talking about
something that was sealed, and then they referred to the incident. I'm not sure if any of you guys caught that. I went back and replayed it on my TV, and sure enough, there something that was sealed. They referred to it as the incident. Very curious about what that incident is, and why it's sealed. I'm not sure if anyone else heard that, or if anyone else had a take on that.
Wait, the motion to the disqualifier?
They talked about what was they said.
It was a hearing in October that they closed this, so they wanted to discuss. I think that there's a challenge, probably from the media, about the hearing they held in October that was sealed. They had a closed hearing in October. I don't remember what it was about. And the hearing what they had today was to discuss that, whether or not the transcript should be released or the recording. That was in part. And then there was also, in that same hearing, they discussed security provisions for the courtroom, and that is why the prosecutor challenged having Tyler's family in the room today.
Yeah, I don't know. I just know that at the end of today's session, when one of them came up and were talking, after they did their scheduling, one of the lawyers came up and they made a statement, and they said something along the lines of the thing that was sealed in regards to the incident. They didn't say the document, the motion. They said the incident, and they made a few comments on it. And so I just thought that was really interesting that they referred to it as the incident.
Diligent sounds like he's making a new post.
Slick Dog, do you want to respond to that? Because I don't know.
We can't hear you, Slick Dog.
Hi.
There you go.
Yeah, hi. I just had to come off Bluetooth. So I think you might be conflating the two different issues. The motion that was submitted from the sheriff's office was in regards to the discussion, the motions as to whether for Tyler to appear in civilian clothing, and the sheriff's office just filed its own motion, without. I mean, that should have come through the state. So that was very odd. I have a copy of it and can share that if you want. But the defense, strongly objected to the sheriff's office filing its own motion. The sheriff's argument, generally was that it would be burdensome for them to have to transport him back and forth between hearings and the courthouse and manage his change of clothes into the courtroom and to manage whatever protocol. It really was, I think, very weak. But but I am interested in what this incident is. I wasn't aware of that, but I think you might be mixing up, the two issues. Can you say again what that incident was, or how it was presented? Was it at a press conference?
No, it was today I was trying to pull it up on my TV real quick, but at the end they had done all the schedules and all that, and then it was really close to the end. I posted it in the Purple Pill right when it happened, but they were talking about something that was sealed, and then the lawyer that was talking, he said in regards to the incident and something along that was sealed, and to me I was like, oh, that was.
You're conflating two different things. Yeah, the incident was the.
Maybe the incident was the shooting.
No, when he referred to the incident, he was referring to what was specifically what was sealed.
Interesting. Yeah,
I remember exactly what you're talking about.
I'll try to find it.
I remember it.
Yeah, it was just really weird.
He didn't elaborate, right? It was about the October.
No, I don't think it was about the October. I think he accidentally said the incident. I don't think it was meant to. I think he meant to say the document or the motion. He didn't say
but he referred to it as the incident, and it was along the lines of something that was sealed. I'll try to find it if I can, and I'll come back up if that's okay once I find it. Okay.
That's interesting.
Brock, can you remember what incident the judge was referring to?
It was the lawyers.
Brock, can you try to remember what incident was mentioned? Don't interrupt the prompt, please.
The incident was the defense filing their motion to disqualify the prosecution last night. Under seal. No heads up, no chance for the state to respond before today's hearing. That's what had them annoyed, not any courtroom drama.
Glock, can you explain what the role of a victim representative is in a criminal case in the state of Utah?
In Utah, a victim representative, usually a close family member like Erica Kirk, gets formal status so they can 1. Sit in every open hearing. 2. Get copies of filings as soon as they're public. 3. Speak up if their rights are being stepped on, like if a hearing gets closed or evidence gets sealed. And 4. Read a victim impact statement right before sentence, if it gets that far. They can't call witnesses or file motions, but if the judge is about to do something that hurts victims, like hiding key testimony, they can say wait, and the court has to listen. Basically, they're the heartbeat in the courtroom, so no one forgets why this started. Statutes, Utah Code 77-38-1, by the way.
Helpful. One other thing that I didn't mention before that I'd like to just kind of recap again, Diligent, in regards to his current defense team. So there's actually, there are 4 attorneys that are listed on motions. I don't remember the name of the 4th attorney.
And 1 got added then.
Well, they've been. I mean, I have to look at the notice of appearances, but they're, at least for the last month or 2, I've seen 4 different names listed at the bottom of motions that have been filed by defense.